A very warm good morning to one and all. Our respected resource person, Professor Emeritus Dr. Balram Gupta, officiating Dean and Head of the Department, Professor Dr. Komal Odich, dear faculty members, and all participants. I, Ajit Singh, Assistant Professor, Faculty of Law, SRM University, welcome you all to the first session of the second day of this ongoing faculty development program on contemporary issues and changing facets of law. It's my pleasure to invite the resource person for this session, Professor Dr. Balram Gupta, who is a rare mix of academic and professional lawyer. Recently, he got his book published entitled My Journey with Law and Justice, whose foreword is written by former Supreme Court Judge, Justice Madan B. Lokur. Eminent people from their fields attended the book release function. No surprise, the book is getting wonderful reviews. Professor Gupta is currently serving as a Director, Academics at Chandigarh Judicial Academy. He has also served as a Director, National Judicial Academy at Bhopal. Dr. Gupta started his teaching career by joining at Faculty of Law, Punjab University, Chandigarh in 1969. He is the second PhD in law from Punjab University. His research work was compared with the best of writings on the subject. Even advanced country became the youngest professor of law in 1983. He has more than 30 years of teaching and research experience. Sir has published numerous papers in various national and international journals. Dr. Gupta has delivered lectures at University of Cambridge, Nottingham, and London in UK. It was in early 1991 he joined the legal profession. He practiced in the field of constitutional and service law. He was designated as senior advocate by the Punjab and Haryana High Court in 2002. This was for the first time that a former professor of law was designated as senior advocate in this part of the country. Professor Gupta has also received many awards and honors. Dr. Gupta was honored with the State Award of Nyaya Ratan by Agrawal Foundation, Punjab. He was honored as distinguished alumni on the occasion of Diamond Jubilee celebration of Punjab University, Chandigarh. On the occasion of Silver Jubilee celebration, the Central Administrative Tribunal Bar Association Chandigarh Gupta for his invaluable contribution. Dr. Gupta was honored with the Lifetime Achievement Award of Rotary International for connecting Rotary and judiciary through his writing and skill. He is appointed Emeritus Professor of Law for life by Amity University, Punjab. The broader theme of this session is Complete Justice, COVID-19 and Constitution of India. 2020 has been a disastrous year for human rights. While increasingly commitment to the upholding human rights standard has been flattening all over the world for several years, the COVID-19 pandemic has accelerated the erosion of the democratic fabric of our society. And it is that fabric of the society on which our protection of human rights ultimately depends. The pandemic has upended our lives in the same way that 26/11 and the parliament attack, and possibly more so. It has also provided many governments with a pretext to fears and crack down on dissent, restricts people's rights, and pass emergency legislation. I think it's not overstating to say that we are at a crossroads. The direction we decided to take now will shape the type of society we want to live in and pass on to our future generation. That choice will determine whether we bolster our freedom or relinquish them, promote participation or undermine democracy, empower people or marginalize them. So, having said that, now I invite Professor Dr. Balram Gupta to enlighten us on this topic and elaborate us. Over to you, sir.
Thank you, Dr. Ajit Singh, for a very generous and warm introduction. Dr. Komal Gupta, other faculty members, and the participants in this particular faculty development program. Good morning to everyone. I'm so very happy to be with you this morning, particularly when Dr. Komal talked to me about this. I was happy at the effort which was being put in by SRM University in the process of faculty development, particularly in the context of contemporary issues focusing on the Constitution of India. I could not have thought better of any other topic than the COVID-19 and the challenge that it threw, particularly in the domain of doing justice within the parameters of the Constitution of India. And therefore, I thought that I would share my thoughts on complete justice, COVID-19, and the Constitution. COVID-19 has been the biggest challenge in human history for that matter. It started 2 years back on 23rd of March 2020, when we had the Janata lockdown. And thereafter, we have been having a challenging situation. When it started, it was virtually a threefold emergency in the country. The health emergency, the financial emergency, the environmental emergency in the country. Constitutionally, we know of a particular emergency as such. But the challenge of all the three emergencies was different, peculiar of its own kind. It seemed as if the entire humanity around the globe was impacted with this particular pandemic that we faced. Normally one thinks such situations are passing situations. We could not have thought that it would get prolonged for years together. We are completing 2 years in this particular process. I was looking into a particular survey. 208 countries around the globe have been impacted with this pandemic. The number of countries is far more than the number of the countries who are the members of the United Nations, working for peace for that matter. And each country had its own challenge. India, its magnitude population-wise, and therefore the ramifications emerging from that particular aspect had its own challenges in that context. There was time in the year 2020 when the dead bodies were not being claimed by the near and dear ones. Mortuaries were full of dead bodies. You were in queue for funeral to be carried out. That was the challenge for the humanity as such. You know, the health workers, the doctors, the police were being attacked. It was a challenge for humanity for that matter, for each one of us. We could not step out of homes, and therefore, in that situation, The first challenge that we faced was, even in warlike situations, the system of courts' access to justice cannot be closed or shut down. It had to be continued for that matter. And therefore, in that particular context, how did we really deal with this situation? Article 142 of the Constitution speaks of complete justice. The Supreme Court of India can pass any order or a decree in any matter in order to do complete justice. This provision, Article 142 of the Constitution, has been originally part of the Indian Constitution. It is not a later addition by amending the Constitution. We need to realize the fact that the framers of the Constitution had such vision that they could provide even during the normal times to do complete justice. Yes, justice is the first promise of the Indian Constitution to the Indian people. Justice, social, economic, and political, the preamble manifests that. But the expression complete justice signifies something different for that matter. Rule of law. Justice according to law. That is the mandate as such. And yet, the framers thought of bringing in complete justice concept. What is this complete justice concept? Why this expression complete justice in the original Constitution? What could be the reason, the justification, the significance of introducing this particular concept of complete justice? It is only the Supreme Court, the top court, the apex court of the country, which has been bestowed with this jurisdiction to pass any order or issue any decree in order to do complete justice. Neither the high courts nor the district courts can invoke could be vested, could be trusted with this kind of jurisdiction. And therefore, the framers carried it out.
Excuse me, sir. So you got disconnected for a minute. So could you please repeat?
All right. Thank you.
You got disconnected. Thank you so much.
Please. You know, I was just explaining why the top court of the country has been vested with this particular jurisdiction. This jurisdiction is to be invoked sparingly in extraordinary situations. And therefore, who could be possibly trusted with this jurisdiction? Only the top court of the country. The framers thought it appropriate to do that, and I am one with them in limiting it only to the top court. Having said that, what is this complete justice? Why this specific provision in the Constitution? The framers of the Constitution justified by saying complete justice is something like natural justice. Natural justice above the law. Complete justice above the law. Now you would ask me, and feel free to do that even later when we interact. Above the law? Is natural justice something above the law? Yes. Even if the law does not specify the adherence to the principles of natural justice, yet natural justice principles always stand that they have to be applied. If you wish to do justice, justice naturally, obviously in that situation, the principles of natural justice come into operation. Natural justice, what does it mean? To do justice in a natural manner. The basic limitations in the sense that without those principles, justice is not possible. There is a dispute. There are different parties involved. Can you do justice without hearing the parties? Basic principle of natural justice. Even if the law doesn't provide for it, yet the principle of natural justice of odi alterum partem has to be adhered to. That is the requirement for that matter. And therefore, it is above the law. Natural justice is above the law for that matter. Even if law doesn't provide for it, yet you have to do it, apply it. The one who is to decide the matter, dispute. No bias, no prejudice. This is something basic. A judge must have an impartial mind, impartiality in deciding the matter. And therefore, again, if you wish to do justice, it doesn't need to be put in law. So the judge has to be above any prejudices and biases in his or her mind. And therefore, in this context, similar aspect is applicable to complete justice. Normally, every court, every judge, every bench is to do justice according to law. But if there is a situation, the law comes in the way of doing justice, doing complete justice. Does it mean that you have to follow that law and divorce deciding that matter from doing complete justice? The mandate of Article 142 is to do complete justice. If there is a law which comes in the way of doing complete justice, is that law not unconstitutional? Why do I say that? The test of a particular legislation is on the touchstone of Article 142. And if that particular test does not carry out the doing of complete justice, that law is in violation of Article 142 of the Constitution. I would put it that Article 142 is part of the basic structure of the Constitution. Any law which is violative of the basic structure of the Constitution, is that not unconstitutional? Look back to A.K. Gopalan's case. Article 21. Procedure which was prescribed statutorily was followed. But the question was that procedure reasonable, just and fair as it is required under Article 21 of the Constitution? A.K. Gopalan. What they said was, whatever be the procedure, that's the rule of law. Irrespective of the fact, is that law reasonable, just and fair or not? We must strictly follow the procedure laid down statutorily. We moved forward. We came over to Maneka Gandhi. And in that, it is not every procedure, it is only such procedure which is reasonable, just and fair, which is the requirement of Article 21. And therefore, the court could go into a particular legislation and see whether the procedure laid down is reasonable, just and fair or not. Similarly, under Article 142 of the Constitution, it would look into the procedure laid down, the law which is stipulated, and see whether it is hampering the doing of complete justice or not. And if the top court, the Supreme Court, finds that yes, it is obstructing the doing of complete justice, then in that situation, it would be unconstitutional, violative of Article 142 of the Constitution. This is why it is being said above the law, like natural justice. The ultimate object of the Constitution, the mandate of the Constitution, is to do complete justice. And if any legislation is in the way of doing complete justice, it is not to be valid and therefore to be struck down. Either interpret as to how you would ensure that within the parameters, the provisions of that particular legislation, complete justice is done without declaring that legislation to be unconstitutional. If that is not practically possible, then in that situation, it has to be struck down. Though sparingly, the effort is to be to treat that law as valid, interpret that law that it does fulfill the parameter of doing complete justice. But if this effort is not possible, then you need to go over to the other aspect, declare it, to ensure that complete justice is done. That is what is required. Now take, for instance, how do we deal with the pandemic situation and Article 142? I come into that realm now. That's a very important aspect. The first challenge was that how to provide access to the courts during the pandemic times. We have been used to, for 70 years, physical system of courts. I myself have spent 55 years in classrooms and courtrooms. That is the real thing that we have been playing that role for so long. It was impossible to meet physically. And therefore, it was an opportunity to make use of technology. We had to transform ourselves from physical system of courts to virtual system of courts. How did it become possible? The Supreme Court of India invoked Article 142 that the courts will not be closed down. We would make use of the technology and resort to virtual system of courts across the country. That was a big challenge. But this we fulfilled by resorting to virtual system of courts. I agree with you, virtual system of courts is not an equivalent substitute for the physical system of courts. I agree with you. Particularly the technological glitches and hitches manifested themselves. Yet, look into the entire background that today we are into. We have adapted ourselves. The courts have adapted themselves to this system. And therefore, technology has made it possible. And the courts got the opportunity to invoke Article 142 of the Constitution and get into this particular realm as such. This is the beauty of the flexibility of a system for that matter. You know, physically we could not meet. The most impacted, the courts, the universities, the colleges, the schools. But this technology has really come to a rescue for that matter. It has become possible. We can meet I can share with you my thought process. If this were not possible, we would have been deprived of it. And therefore, this excess of justice through the virtual system of courts has allowed the system to continue not only in India, across the world for that matter. I could, in a class, address a small number of students. I've now addressed, during the last 2 years, at a time, thousands of people. This is the benefit of the technology that we are having today in this context. When I'm talking about Article 142 and the virtual system, of course, let me also, once I'm talking about the faculty development, the young law teachers in a country for that matter. You know, there is a strong case made out from virtual system of courts to live streaming of the courts, the proceedings of the courts. In the year 2018, Tripathi versus Supreme Court, a case came up where a 3-judge bench dealt with this matter regarding live streaming of the court proceedings. At that time, there was no pandemic. We were normal times we were going through. And a student of law had come to the Supreme Court with a petition saying that I am unable to attend the proceedings, particularly of the constitutional bench cases, which are so important for the students. And let me add, not only for the students, for the faculty development also. If live streaming of Keshavananda Bharati's case or Maneka Gandhi's case, how useful it would be for building up the law faculties as such. You know, the courtroom becomes a laboratory for the teachers of law, for the students of law. That's the beauty of live streaming as such. I recall my teaching days in the Punjab University from 1969 to 1990. Each new group of students, I used to encourage them that I will let you know that in the High Court, prominent lawyer is going to argue a particular important case. You must go and watch over there. I used to encourage them. Some of them used to go, sit through the court proceedings and watch. You know, for a budding student of law who wishes to be a lawyer, wishes to be an advocate, his exposure to the courtroom, he would develop his skills, lawyering skills for that matter. And if we can have live streaming of the court proceedings, what a beauty that your Home becomes the classroom, the courtroom for that matter. You can expose yourself to that. Sitting in the hostel room, you can watch the court proceedings. Would be such a learning for the law professors if they're exposed to the significant cases in that particular context. And therefore, what I'm urging today, that this was something which was said to be in that 2018 case, Chief Justice Mishra, Deepak Mishra, Justice Khanwalkar, in their judgment, and Justice Dr. Dhananjay Chandrachud, in his concurring judgment, said that access to justice is integral to Article 21 of the Constitution. And therefore, if virtual system of courts is possible, why not the live streaming, particularly when we would resort to physical holding of the courts? The physical holding of courts is something altogether different. You know, let me share my own experiences at the bar. Some of the judges would speak so softly, it became difficult to even understand what the judge was asking. The audibility was so difficult. And many a time when you argue a matter and seek the order, which even with effort you couldn't pick up as to what the judge has dictated. You think you have been granted the stay in the matter, and when you come out to know, oh, it has been rejected. That was the kind of difficulty. In physical system of courts, the body language of the judge makes all the difference for a lawyer to nurture his argument, to really mold his argument in a particular context. Let me share with you an English judge in an English court in England was in the habit of bringing his pet dog along with himself to the courtroom. The dog was so well tamed, the dog is sitting and the judge is concentrating on the cases which are being argued. No disturbance, absolutely smooth court proceedings. A lawyer, a barrister, was arguing a case, and suddenly the judge started looking at the dog. The lawyer stopped, the barrister stopped. The judge asked him, "Why have you stopped?" And his response was, "I thought my lord was in consultation." You know, when two judges bench, they consult each other, they talk to each other. And when he was looking at the dog, the barrister says, "I thought my lord was in consultation." In other words, when the two judges consult each other, they talk in whisper. A lawyer needs to pick up even that whisper, which is possible in the physical system of courts, of course. But I'm sure when we talk about the live streaming, the public address system would be introduced in our courts, which would help the entire system so effectively as such. Another thing, live streaming would lead to discipline in courts. Judges would know that they are being watched, and therefore they would be conducting the court and making whatever questions are asking different questions in such a manner which would be effective to demonstrate that the judicial discipline, holding the court on time if live streaming is there, would introduce regularity, punctuality in a system for that matter. And therefore, I can go on with the benefits of live streaming and the virtual system of courts as such. This could be possible because of Article 142 of the Constitution. Let's go to another situation. During the pandemic time, it became difficult for the lawyers to file cases within the period of limitation. In the sense, physically, they were not in a position to do that. They were not allowed to do that. And if a suit is to be filed within a specified period, say 3 years, or appeal is to be filed within 3 months, or any other limitation under any other legislation under the Limitations Act or other different legislations. This was again around the country a difficult situation during the pandemic time. Once again, the Supreme Court invoked Article 142 of the Constitution and passed a general order extending the limitation period till further orders, meaning thereby the law which provided for the limitation periods, that law was silenced by this particular order as such. Not that the provision was declared unconstitutional, not that, but that would not be applicable during that pandemic time. Even recently also they have further extended it because the situation demanded it, warranted. The situation was such that it was warranted, and therefore they did that. This is what actually Article 142 makes it possible in that context. I give you a third example, a very practical example. During the pandemic time, social distancing, masking became very important. Our prisons are overcrowded. You know what is the situation. Again, if there is so much of congestion in the prisons, a prison which can accommodate 100 persons and you have 500 persons, a prison which can accommodate 500 persons, you have 1,500 persons. How to deal with that situation during the pandemic time? It was again a difficult situation. What was done? How the situation was dealt with? A again Article 142 of the Constitution was invoked. And in that particular process, the states, the union territories were directed to constitute high-powered committees. And those committees will in turn look into in what cases under trials and other cases the prisoners could be released temporarily. Interimly, bail may be given, furlough may be provided. You know, ways and means to deal with that situation within certain limitations as such. This actually became possible in the context of Article 142. It was again invoked in that context. Another situation, the pandemic time threw a challenge about the migrants, and therefore migrants are such an acute problem. They rushed to their homes, for that matter, leaving the place where they were working. No arrangements, nothing of the kind. What a challenging situation. Even the Supreme Court did not come to their rescue to begin with. Some of the high courts did come and realized what the magnitude of the problem. And therefore, in that context, what they did, ultimately, the entire thing was regulated. Article 142 came into play, for that matter, once again in that context. I am yet to know any other system where a provision of this kind had been invoked during the pandemic times. And therefore, in that particular context, you know, Article 142 today is an exportable item, exportable commodity. And to share with you, the Bangladesh Constitution already has a provision equivalent to Article 142. The Pakistan Constitution also has a provision equivalent to Article 142 of the Constitution. You know, in fact, during the last 7 decades and more, Article 142 has been invoked, not only during the pandemic times, but even during the normal times. And therefore, a complete justice jurisprudence is developing in our system. What visionaries the framers of the Constitution were when they introduced this provision originally in the Constitution. During pandemic times, domestic violence cases increased manyfold. How that situation was dealt with, what a challenge it was. The J&K High Court had to direct that women suffering from the domestic violence situations, thrown out at night from homes. The High Court of J&K directed the state authorities to provide shelters at night when such situation arises, even during the pandemic times. That was the kind of challenge that we were facing. You know, one has a right under the Constitution to die with dignity. The last rites, they became impossible for that matter. We talk of renouncing practices which are derogatory to the dignity of women. And why only limited to women? Dignity of human beings, for that matter. And therefore, in that particular context, the challenge that we have, this Article 142 came to our rescue so effectively, so meaningfully in that context. Let me focus on another aspect and link it with the pandemic. The fundamental rights and the directive principles, they were integral part of the Constitution to begin with. And the initial situation was that the directive principles were subservient to the fundamental rights, particularly the directive principles, directive principles to the state policy, in spite of the fact that they were fundamental in the governance of the country. Yet the country did not have the actual means, financial or otherwise, to provide education, even primary education. We didn't have those facilities as such. Social justice domain, what a gigantic situation. It was not possible. And yet fundamental rights were fundamental. And these were just directives only, not enforceable through the system of courts. Gradually, directive principles have been harmonized with the fundamental rights. Some of the directive principles have turned into fundamental rights also. What a change that we are finding. And the courts take them, that they both have to be harmonized together and move forward in that direction. I go a step further. Fundamental duties were introduced in the Constitution by way of amending the Constitution. Article 51A was added by way of 42nd Amendment of the Constitution during the internal emergency that we had 1975-77 March. Even the fundamental duties are not enforceable. And now, during the pandemic time, the challenge that we faced, this coparcenary of fundamental rights, of directive principles, of fundamental duties, they need to be harmonized together. Even if fundamental duties are not enforceable. As a student of law, I was taught Rights and duties go hand in hand. You must have also been taught that, jurisprudentially for that matter. And therefore, can we actually divorce the fundamental duties from fundamental rights, or fundamental rights from fundamental duties? Even if the fundamental duties are not enforceable? That's the challenge. Now, what I say in this kind of a situation, if the directive principles could be harmonized with the fundamental rights, why can't we say fundamental duties are the limitations on the exercise of fundamental rights? Fundamental rights are not absolute. May it be Article 19, Article 21, or any other article for that matter. They are not absolute. Why can't we read fundamental duties into the fundamental rights as limitations on them? It's most important. Let me ask you, if I violate my fundamental duty and I go to the court claiming the violation of my fundamental right, will the High Court not be justified in saying, if you have violated the fundamental duty, you have no right to claim a fundamental right? You know, have the constitutional scheme. You can't divorce and say fundamental duties are of no consequence. They carry no weight because they are not enforceable. Why are they fundamental? Why they are incorporated in the Constitution? And is it not the duty of the Supreme Court and the High Courts to give life to fundamental duties also? Make the citizens more duty-oriented if they wish to have more of fundamental rights for that matter? It's the blending which is required. It's the mixing which is required. It is fundamental duties to be read as limitations on the fundamental rights. That's the challenge of the pandemic. Fraternity, assuring the dignity of the individual. If you are hitting and thrashing a doctor or a policeman on duty, for that matter, during the pandemic time, we have seen those situations. Am I not violating my duty? And if I am doing that, what right do I have to claim fundamental rights in that context? And therefore, think it over. And this is the challenge that we need to. This is what needs to be done through the interpretational process. Most important in that context. Having said all this, let me focus on another small aspect. Article 142 is the constitutional morality. Constitutional morality expression has nowhere been used in the Constitution. Morality has been used without the adjective, the constitutional. Only morality has been used in Article 19, 25, 26, freedom of religion, and morality in that context has been used. But constitutional morality, nowhere in the preamble or in the entire body of the Constitution, it has not been used. Like basic structure is the gift of the judiciary, constitutional morality is also the gift of the judiciary through the judicial interpretational process. And do you know, in Keshwananda Bharati, basic structure was laid down. And the expression constitutional morality was also used in Keshwananda Bharati's case, which most of us, constitutional scholars, professors, have overlooked that. In some of the cases, constitutional morality is playing a role, significant role in the interpretational process as such. What is this? Isn't Article 21 reflective of constitutional morality? Isn't Article 14 reflective of constitutional morality? Good governance emanating within the parameters of Article 14, eliminating discrimination, arbitrary actions, integral to good governance, that is integral part of constitutional morality. We are gradually developing that. Similarly, doing of complete justice is constitutional morality. And therefore, we have to see how meaningfully, wholesomely we can make use of this most potent provision of the Constitution and make it integral that complete justice is constitutional morality. In such challenging situations would really be focused through such blending, such mixing of the provisions of the Constitution. You know, these were some of the thoughts that I thought I would share with you all. And in that context, I'm sure I should have been able to provoke you to interact the challenges that we are facing today, how to really handle those within the parameters of Article 142, within the parameters of constitutional morality, and blend them together. Give a serious thought to harmonizing the co-partnership of fundamental rights, directive principles, and fundamental duties, particularly reading the fundamental duties as limitations on fundamental rights during such challenging times that we are facing today. That's the challenge. Let's pocket the challenge and see how best we can contribute in this particular process. I would be too happy to interact with you all. This is what I wanted to share briefly for that matter. Over to you, Komal.
Very much, sir.
Thank you so much, sir. Yeah, Ajit sir, start with that interactive session. There must
Now
be
the
some
session is
questions.
open for question and answer. Any suggestion? The participants who want to ask question, they can raise their hand and they will be unmuted. Or they can write in the chat box as well, whatever they feel convenient.
I think meantime, I can ask a question to sir.
Sure, ma'am. Sure, sure.
Sure.
I think being your student, I have the first right to ask a question. So
Even without being a student, you have the first right.
yeah. Today I'm just like any other faculty member. So my question is that we know our right to health is a fundamental right, as has been declared through many Supreme Court decisions, although it's not an absolute right. And somewhere we know that this public health under the 7th schedule is the subject of state list. But when we had the first wave, and we know that the state's legislative executive power is coextensive with the center's legislative power. And the state government had the primary role to look after health and law and order situation. But during the first wave, the center took over because the kind of at the national levels, orders had to be passed for lockdown and for other public health systems. So the states allowed the center to take over, and it became more unilateral or over centralized, at that time response. But at that time also, the center faltered when it came to migrant laborers case and other things. And during the second wave, it was altogether different. There was a breakdown of interstate relations, and the center also could not fulfill its part to handle the situation. And it lost, many situations where it could have, like the vaccination policy and all, and how the states, and moreover under GST also the state could not get the financial help, and it was the breakdown of interstate as well as center state relations. Of course, the Supreme Court intervened. It tried to resolve the deadlock. But my question to you is, somewhere during the first wave and the second wave also, the fundamental rights, whether the Supreme Court could do complete justice, whether Supreme Court could play the active role to protect the fundamental rights of the people, as you just mentioned how the mortuaries were full and the doctors and nurses were being attacked. So somewhere there was a failure in the second wave. And the Supreme Court at that time, whether it could play that active role and it could come forward to do complete. Because for me, when I saw the migrant workers thing, and about everyone's opinion was that was the darkest period of Supreme Court's history. So do you think that Supreme Court should have played more active role to do more complete justice? The jurisprudence which it follows.
Add on to it, ma'am, one of our participants is also asking the same question. So, sir, would you please like to answer?
Sure. Let me respond to this. We all feel the Supreme Court could have done much more than it actually did. But let us balance ourselves. The challenge, particularly with regard to the health services, was a challenge unprecedented, made with the center, made with the states, made we collectively together for that matter. It was something enormous beyond one's comprehension in that situation. Now, each organ has its own limitations. We know what the people, the public health for that matter, is facing. Constitution guarantees you certain rights, no doubt about it. The courts, while dealing with such extraordinary situations, cannot close their eyes to the practicability of the situation, the actual situation which is there. And therefore, in that particular context, to think that the Supreme Court, in order to do complete justice, should have done this also as such. But the question is, if you order certain things which are practically not possible to be implemented, to be carried out. Take, for instance, the scarcity of oxygen during the second wave as such. That was something for life-saving purposes. But could it be said by the Supreme Court, make sure each hospital, big or small, should not face any scarcity in the supply of oxygen as such? It's a question of supply demand. We cannot divorce ourselves to the situation which is there. Why am I saying that duties need to be read as limitations on our fundamental rights? We cannot close our eyes to that. The courts could not do that. You know, I believe in one thing. Is it practically possible? Yes, the second wave threw a challenge, particularly in terms of public health. We could meet that challenge to an extent, not to every extent for that matter. And we are better prepared for the future. That is what is required. We need to learn in that context. And therefore, I would urge each one of you, think in terms of the practicability as such. Why were the directive principles initially not really being implemented or carried out as they are being now after 7 decades they are being carried out? The reason is obvious. We have now the resources. Right to education, primary education. It has become a practical possibility as such. And therefore, let us be more balanced in our approach when we talk about how much more could be done by the Supreme Court. Yes, so where the migrant labor is concerned, I would be one with you. Right from the beginning, much more was required from the Supreme Court. But it didn't happen. Gradually, when the high courts came into picture, the Supreme Court also stepped in. A damage had been done to a good extent by that time. But then, that was a challenge as such. In this context, so far as the public health part is concerned, right to public health, we have to see our means and then think of what was possible, what could not be possible, and centralized aspect of it, as Komal is putting it. You know, probably situation demanded that at that particular point of time. Unitary federal elements. Our system is flexible. The center is the umbrella. It needs to come to the rescue where a situation demands. Thank you. This is what I would respond to this particular question. I know you may not be agreeing with me, but but question is, what is practical?
Thank you so much, sir. No, I do agree that center had to act like an umbrella, but in the second wave, it faltered because it had taken over in the first wave. In the second wave, center faltered, and they totally ignored the third tier of the government system. Panchayats and local municipal bodies. They were totally ignored. And the second thing is, sir, what you just said, what Supreme Court, whatever it could manage. But the thing is, when we say right to health is a fundamental right to man, that's the jurisprudence which must be by the Supreme Court, see whether it is being followed up or not. We always, really praise the certain decisions of the Supreme Court when they come, and we say it's playing an active role. But somewhere, I think it's lacking in its follow-up. That's my opinion.
Komal madam. Komal madam.
See, you are entitled to your opinion.
Yes.
So am I entitled to my opinion.
Of course. Thank you so much, sir. Thanks a lot.
See, unless we agree to disagree, there is no further moving in that particular context.
Yes.
Yes, sir. Yes.
Can I ask a question?
Thank you so much, sir. Yeah, we have our faculty, D.D. Sharma, sir. He also wants to ask you a question. Over to you, sir.
Yeah, thank you, madam. Sir, thank you very much for such an enlightening and thought-provoking. I think all my faculty members would be motivated to look deep on the subject. I am a retired banker. I just want to make one comment, sir. It is not only on the lofty principles of fundamental rights and fundamental duties and principles of natural justice. There was a borrower, and that borrower was playing havoc with the banking system of the country.
Yes.
He was also defrauding the public at large. And the Honorable Supreme Court found it so difficult to deal with that borrower that whatever order the Honorable Court passed, he found a way out to subvert the directions of the Honorable Court. In that challenging situation, the Honorable Supreme Court invoked the Article 142 and passed a direction in the matter that all the court cases, that all the securities of that borrower and all matters related to that borrower were directly dealt with by the Honorable Supreme Court, and all the family members of that borrower, including the daughter-in-law of that borrower, were sent to jail. So I support your contention that to give complete justice, like even in a mundane matter like a banking matter, the Honorable Supreme Court invoked the Article 142.
I'm so very happy that you have shared this particular situation. It's not a mandate situation. Each domain has its own challenging situations. This was a challenging situation in the domain of banking, for that matter.
You're right.
That is why I say Article 142 is something which can be made use of in different situations, in different jurisdictions, in order to handle a situation for that matter. In Vishakha's case, for instance, the directions which were given, which remained in vogue for so long, for 2 decades as such, it was only by invoking Article 142 of the Constitution. There are certain provisions, like for instance, basic structure. I know there are many constitutional scholars who do not think positive about the basic structure of the Constitution. That where is the provision in the Constitution for basic structure not to be damaged or destroyed. The question is, if there was no such interpretation of basic structure in 1973, I pose you a question. What would have been the shape of the Indian Constitution? Similarly, Article 142. You have shared this example of banking. I can share with you many more as such, but this is one provision which is omnipresent in the Indian Constitution to deal with different, hard, difficult, extraordinary situations. I have said this, it is an exportable item. And therefore, let us take pride in a system, constitutional system, that we are exporting certain things which we have experienced to be of utility for the people, for the public, and in different difficult situations. Yes.
Thank you so much, sir. Ajit, sir?
Yes, ma'am.
Are there
There
any
is
other
one.
questions? Yes.
Yes, ma'am. Yes, ma'am. One of the participant has asked, though pandemic has affected every walks of life, be it the business community, be it the legal profession, they were affected by it. But how far complete justice to the student community have been provided? I think
Please.
the concern here is the student community.
Good that you're asking this. I personally feel the students, not only the law students, but the students across the board, schools, colleges, universities, at all levels, have suffered the most. What they have lost is something which would never come back to them. Speaking personally, what you can share with the students, face to face, interact with them, physical part of it, this is no substitute. In Chandigarh Judicial Academy and academies across the country, including the National Judicial Academy, the young judicial officers who are selected, we provide them with foundation training. During the last 2 years, no physical foundation training to them. In a way, they were students, those selected as judicial officers after the selection process as such. Conducting of mock trials. I wanted to convert the classrooms of the academies into courtrooms. But virtually this is not possible as such. Let me share with you Article 142, to do complete justice. I would agree with you all that it has failed to but then they are also part of the system. The pandemic, whatever best could be done, was done. This best was not actually the best. Best would have been possible if physical meeting of the students with the teachers, classroom interactions, that is most important. I know they have suffered the most. I said it right in the beginning also. But then what actually you can do in this context. We have limitations in regard to this, and Article 142 also is pregnant with certain limitations of its own. Please.
Thank you so much, sir. Ajit, sir?
Yes. Ashwati ma'am is asking one question.
Thank you, sir. Good morning, sir. So my question is with respect to, could this onus of providing complete justice to some extent be taken up by the lower courts and lower judicial authorities as well? So I'm asking this specifically with respect to a situation which happened in Delhi in 2021. So the Delhi High Court came to realize that the juvenile justice boards in Delhi were letting cases of children in conflict with law alleged with petty offences go on for around a year or so. Whereas the Juvenile Justice Act specifically says that it should be completed within 6 months, and if not, then it has to be stopped right there. But the problem was that the juvenile justice boards were interpreting this provision in such a way that from the date the child is produced before us, from there 6 months. And it came to the Delhi High Court's attention that these children were never produced before the court at all, before the Juvenile Justice Board at all. And since they were never produced, the case was going on for around a year. So then the Delhi High Court had to step in and say, this is not how the act intended it. I mean, you have to produce the child as well. And if not done also, then also within 6 months, the case has to end. So the problem is somewhere that the lower courts are maybe being too technical and they're not thinking about what was the intention behind the provision, perhaps.
Please.
It's a question or an answer, ma'am?
Yes, sir. So how could the lower courts also think about, I mean, take up some of this onus of doing justice, not place the entire onus on the higher judicial authorities as well?
You know, let me put it this way. Children in conflict with law. That's a very important domain. Juvenile Justice Act deals with the entire spectrum in this particular context. We, even in the judicial academies, conduct workshops relating to this particular domain, for that matter. During the pandemic time, yes, this was also another area which was impacted. And as you focused, there were certain practical difficulties, no doubt about that. But then let's not forget, they are also part of the system. If students otherwise have suffered, also they constitute a separate class category as such. There is a law to deal with them. Law could not be, or the courts could not be, or the juvenile boards could not deal with those situations. For instance, virtual. What actually could be done by producing the juvenile, the child dealing with conflict of law situations physically, surely it could be possible through a virtual process to that extent. And therefore, we do have limitations in this context. I understand and appreciate this. And as I said, Article 142 could be said to be a recipe for every situation to be dealt with. Yes, you are wanting to ask a question, please.
Thank you so much, sir. Ajit, sir, someone raised a hand.
Yes, Hartesh sir is there.
Okay.
Yes, sir. Am I audible?
Yeah, you are audible, Hartesh.
Yes.
Sir, in my opinion, the power under Article 142 transforms a judicial body into an executive body. And this executive sort of nature of the court is without any accountability. Now, when we talk about the political executive or the bureaucratic executive, they have some accountability. Whereas under 142, the judiciary, when it is transformed into some sort of executive role, whether it is dealing with political questions or policy decisions, it ceases to have some sort of accountability. It cannot be held accountable as to what all decisions it has made. So, is that in the scheme of separation of powers something that is right? Because if we go back to the original sort of separation of powers doctrine, it is stated that it is emphatically the domain of the judiciary to declare what the law is, not to go into these political questions or questions related to executive or administrative decisions. This is my first question. And my second question is, when the law officers of the country itself, like the Solicitor General of India, go before the courts during the time of COVID and blatantly lie, what sort of action can be taken by the court against those sort of errant law officers who are trying to mislead the court? Because I realize that as far as the constitutional courts are also concerned, they have certain limitations, that they have to treat the law officers of the country like the Attorney General, Solicitor General, and ASG with certain respect. But when they are blatantly lying, saying that there are no migrants on the road, there's no deficit of oxygen, then what is the sort of the stick that the courts can use in order to bring them into line?
Well, if I have understood him, the jurisdiction of doing complete justice, 142 with the Supreme Court, if it could be with the executive, I don't know about what exactly he was focusing on. Could you just elaborate what exactly his issue is?
Sir, he wants to know whether, when it comes to executive action of legislature or executive, they have accountability. But in the case of Supreme Court, this aspect is lacking.
Fine, just a minute. Let me also break this myth of accountability. The executive accountability and the legislative accountability. Yes, we focus on 5 years elections, and they're accountable to the people for that matter. And there is no accountability in your view so far as the Supreme Court is concerned in exercising Article 142. Ask yourself, I don't wish to say anything on this. During those 5 years, say the political executive in the parliament, the legislative aspect of it, the parliamentary aspect of it, they are under the Constitution. They can enact legislations which are as per the Constitution. Many legislations are passed which are not as per the Constitution. The court declares them to be unconstitutional. Similarly, what are we talking of Article 142? 142, to do complete justice, if a particular legislation has been passed by the Parliament which is obstructing the doing of complete justice, the 5 years, whatever the Parliament does or the executive does, it carries. Yes, matters come before the courts, and the courts examine whether they are in consonance with the Constitution or not. True. Take in the system of courts. We have a hierarchy of courts. The courts are also required to be under the rule of law, under the Constitution, act in accordance with the Constitution. If at the district level I pass an order, I write It is examined. I'm accountable, answerable. And haven't you seen how many judgments are struck down by the high courts? And how many judgments of the high courts are struck down by the Supreme Court? And the Supreme Court itself overrules its earlier decisions. And therefore, at each level, there is accountability. They are working under the Constitution as such, and not above the Constitution, for that matter. Two, think of it, many a time, certain legislations which are required, they are not carried through. Why? Because they become a limitation on the executive. And therefore, this is a system where ultimately checks and balances. I'm sure you would agree with me. No one can be given the absolute power. I agree with you on that. Give a power, put a check. You balance the power. Absolute power is not within the constitutional system possible at all. And therefore, in this particular context, I think we have to, each organ has to play its role within the parameters of the Constitution. We are all accountable. And yet, system of checks and balances needs to be in place to ensure that it is carried out effectively. This is what I would respond to your question. I don't know whether you would agree with me or not. That's again, we can agree to disagree also. That's the beauty of a democratic system. You are entitled to your viewpoint, I'm entitled to my viewpoint as such. Yes.
We most of us agree with your point of view, sir.
Thank you very much, sir,
Thank you
for
so much.
patiently answering all those questions. Now I would request our head of department, Professor Dr. Kamal Orich, to kindly propose the vote of thanks.
Thank you so much, Ajit sir. I feel very honored to propose vote of thanks to my most revered teacher, Professor Balram Gupta. Today, the topic was Complete Justice, COVID-19 and Constitution of India. So this session has been, sir, very, very enlightening, very informative, and also thought-provoking. How you started with the topic that the pandemic had created havoc all over the world. It was not just few countries, more than 200 countries got affected. And it was a challenge for the humanity. But somewhere, since the justice is the first promise to the people of this country through Constitution, complete justice played an important role through Supreme Court. And very aptly you mentioned that it has to be under principle of natural justice and it is above law. And being part of basic structure, it's a very, very important aspect of the Constitution. And Supreme Court played this role to the hill during pandemic also, because the access to justice was never denied. The courts were not closed, virtual courts carried on. And another next step has been taken now, the live streaming of court proceedings. What you suggested, that would bring various advantages, not only the discipline amongst the lawyers, not only the transparency in the judicial proceedings, but also learning for the law students while sitting at home only. You talked about, sir, under trial prisoners also, I mean, to do complete justice, they could be released on temporarily, of course, with certain limitations, and how this can play an important role there also. Because I think we always know that under trial prisoners' plight is the worst in this country. And how under the complete justice only the court had another challenging role to play when various domestic violence cases and other came up before the court during pandemic. The important aspect of today's talk was how you put emphasis on fundamental duties. We have many decisions where we know that fundamental rights have the harmonious relationship with the directive principles. But the most important aspect which you said was that fundamental duties can't be divorced from fundamental rights. And somewhere rights and duties go hand in hand. And we should know that first the fundamental duties are there. We should be duty oriented rather than asserting our fundamental rights all the time. And very beautifully, you related Article 142, the complete justice with constitutional morality, which is not anywhere mentioned in the Constitution, but it is a gift of judiciary only. So today, I could never miss your class, when I was your student in Punjab University. And in fact, whenever I'm attending any session of yours, I go back to that time only. And today also, I didn't want to miss. I said, no work, no administrative work. I have to attend this session from beginning to end. And in future also, I just make a request that you bestow your blessings on my colleagues also. And whenever you can take out time from your busy schedule, you just enlighten us, the various aspects of constitutional law. And I think that's your forte. So thank you so much for today's session also.
Komal,
yes,
let me put it this way. Whenever you have asked me, I have never disappointed you.
Yes, sir.
And you have extracted a promise in a way for the future also. In the sense, I look forward always to any such opportunity. It's a joy, it's a delight to be with the young minds, interact with them. I wish it could be more on physical platforms as such, but then let us make the best use of what we have today. Thank you so much. I've enjoyed my morning. Look forward to another session with you sometime. God bless you all.
Thank you so much, sir. Always looking forward to every session of yours. And thanks again for giving us so much time today.
Thank you.
Thanks a lot, sir.